Hey everyone, we're here talking about how to file a design patent application. And hold on a second. Oh, sorry, I left my AirPod in. Did you know that AirPods, super popular? I think Apple sold over 900,000 just in 2018 alone. But did you think that there's both design and utility patent protection? We'd be right. So AirPods are covered under at least one US design patent. Okay, the case, together with the two AirPods under design D801314. There are 44 total patents that protect the Apple AirPods. All right, we're going to talk today about design patents and what it means to put together an application for submittal to the Patent Office. I want to introduce Bold Ideas, the Inventor's Guide to Patents. I wrote this book just a year and a half ago, and I encourage anyone out there that's interested in getting into this subject matter, maybe is just starting, or kind of wants to refine and kind of take the dust off of the knowledge you might have had in the years past. This is the book to start with. Okay, it's at 110 pages, easy read, not legal jargon. This cuts through all the major questions that almost every inventor has about what's the major difference between eligibility, patentability, the difference between patents and trade secrets, all the good stuff. So please go to our website at boldip.com and pick up your free copy today. So without further ado, I want to introduce myself. I'm J.D. Houvener. I'm a registered USPTO patent attorney, managing partner here, and CEO of Bold Patents Law Firm. I'm here today to talk with you about design patents and what it means to get your design filed and patented with the USPTO. So first and foremost, with the overall idea of designs, understand the major difference between design and utility. Design patents protect just the ornamental way that something looks, right? Back to our AirPods, right? You see how this is curved in shape and it has, fairly symmetrical edges. But the fact that it has this hinge and it moves seamlessly, that's not covered under the design patent. Just the fact that it looks like this, right? And that it has a hinge on the top and it's proportionally sized, or it's on the upper portion, and that the shape is sort of hemispherical, right? All those details about just the appearance, that's what's protected under design patents. So the shape is really the heart, right? The ornamental appearance of what your invention is. That's what you're going to be able to protect with a design patent. All right. And so what I want to do is walk with you a little bit about the essences of the application. Okay. What are the different parts of it? If you're in a hurry and you can't watch this whole video, I've set up sometimes in the table of contents format for you to jump to the section that you want to hear more about. I want to mention first off, just like utility patents, one of the key things about design patents is measuring patentability. And you start by doing a novelty search. So with design patents, it's a little bit harder to do keyword searching. Whereas utilities, of course, you have all the functional aspects, the written description. There's a whole lot more to work with in terms of what to search for. With a design patent application or a potential app, all you have is the shape. Okay, it's hard to search shapes. Now with technology, we're getting better and better, but it is essential to conduct a search to confirm that what you've created, this ornamental shape, is actually new. So do your own homework first and then hire a professional to get the search done right. Once we confirm there's nothing else out there and that we don't think it's an obvious variant of another prior art that's been filed, you've got it. You don't have to show utility because that's not what you're going to eventually be able to claim. The next step is the application drafting. The preamble. The preamble is called the preamble, right? Just like the Constitution, it sets the stage. This is your title and describes who the inventor or inventors are. The title needs to be quite simple. And again, it needs to describe the shape and the contour, the ornamentation. Those are the kinds of attributes you should be highlighting in the title. You shouldn't be coloring it with any functional language, and you should not be embellishing the title. Keep it really short and sweet. A nice example for a title might be dual earbud compartment, right? Something similar like that. That's it, and move on. So, simple story about how to make sure that your invention is not functional, all right? And to decide whether or not to file a design versus a utility. There's a Supreme Court case, Brandier, we can highlight that here. This case was all about a bike rack. You've probably seen bike racks that look like this all around town. And it's just sort of become the standard. It started out actually being a work of art. Okay, this was a sculpture that this artist created. Now, it had a sort of an industrial application, and it was awarded Industrial Design of the Year, right? Way back when. The interesting thing is that it is unprotectable under copyright law because of the nature that it is indeed extremely functional. So there's this interplay between functionality under utility patents and copyright. Okay, so there's utility and copyright. You have sort of this boundary that as soon as something becomes functional, it belongs in the domain of utility. Same goes for your design, right? If you're out there, you're an artist and you're designing something, as soon as it becomes functional, it's not going to be eligible for design patent application. It's going to get rejected. What you're going to be able to claim is merely the ornamental appearance, okay? What it looks like. Back to that shape discussion we talked about before. What do those curves look like? What are the relationships and the proportions? That's what's protectable under design. So in the application itself, you're going to need to mention cross-references. The cross-references are really the other applications, the patent applications that you're being able to stand on their shoulders, right? You're using what's been done before, whether it's string, you're tying your earbuds with string, or you're putting them together in some compartment, but it's wired, right? Those are the references, right? And the actual shapes and designs that came before you. So you've got to be able to give credence and give some credit to those inventors before you. And that's what the examiners will do when they perform their search. They're going to start with those references and the citations that you have. The claim, right? So we talked about in a separate video about, oh my gosh, all the hard work that goes into writing a utility claim set. Design patents, it's one line. I mean, I'm serious, it's one line. It simply says, the ornamental design as shown and described. That's it. Everything about your invention lies on the drawings or photographs in rare cases. So drawings in a design patent have additional requirements on top of those that are required at a utility level. The design patents must show all surfaces, okay? And so if the surface has depth to it, curvature, it must have proper shading. And shading is huge in terms of design patents. And so at a firm like ours, we've got a dedicated patent drafter that works with our inventors and our patent attorney to make sure they capture that three-dimensional shape perfectly. So if you want to know more about this, one way to make sure you know that there is a blog on our website at boldip.com. Go look up and see how to file a design patent. I've got what I'm talking about here today in great detail. Okay, you can go inquire there, ask additional questions, comment. Please give us a like on this video. It's going to help us reach a really broad audience someday, and I'm so excited that you're here and you're a catalyst helping us pay it forward and serving the inventor to chase their visionary dream and make it come true. So you've gone through, you've laid out the description, the claim, you've got the preamble, the inventors are laid out, and now you've gone through and started to draw out your drawings. So this is, again, the heart of the patent. Design patent is the drawing itself, the shading, the different angles, and the way you can view the patent in those drawings is also important, right? But you can't miss this, right? This is the number one thing to get out of the drawings, all right? If you're going to think about one thing, focus on this. Patent drawings, design patent drawings, take a careful look. Some have solid line and some have dashed line, outlining parts of the invention. The parts that are in solid line, that is what's being claimed. The parts of the drawing that are in dashed lines are not being claimed. Now, there's a very strategic approach to what features of that invention that are in dashed line and what are in solid line. So if you remember back to our different video talking about utility patents, we tend to want to claim a very essential core, skeleton, bare bones, most simplest version in our independent claims. The same approach applies, but we want to get the inventor the broadest rights possible. We want to be able to only patent, right? Only claim the core essence, right? That limited amount of disclosure, so that then they can get the rights for any additional bells and whistles that are added on it. So take a look at this design patent that was just patented by Apple. All right, so you can see here, Some aspects are in solid line and some are in dashed line. Yeah, that means for the area that's in dashed, that shape could take on any shape, right? It could be that contour could totally change, but what's not going to change and what this rights holder, Apple, doesn't have the ability to change is what's in solid line. That's what's being claimed in this design patent. So I'm so happy to have been able to share this with you. Design patents are near and dear to me. One thing I want to make sure to mention is that in many, many cases, a utility patent application, right, should also be filed, right? If you are an inventor and you've got a new product that has a beautiful shape and ornamentation to it, you think that's protectable, don't stop there. If what it's doing is providing valuable functionality, let's take a look and see if we can also lock down what your invention is doing in addition to the way it looks. All right, and so design patents aren't any different. We're going to still need to gather all the formal documents to get them submitted to the patent office. That's going to include the cover sheet, an oath or declaration, the drawings, and the written description along with that claim we talked about. So collecting all that information, making sure that it's all perfect, USPTO fees are paid for, that is all you need to get your patent pending. Last but not least, you're using the electronic filing system. This is the last step, working with your patent attorney and a paralegal if they have one to get everything filed electronically to save you some money. That's going to be the way to go. So before I go, I want to make sure you give us a like, share this video, and talk about in the comments below any additional questions you might have, follow up, feedback on the video. I'm always looking to improve. Last but not least, I want to also give the opportunity to please read through my book, Bold Ideas, The Inventor's Guide to Patents. This gives you all the essential nuggets about design patents, utility patents, and more. It's available for free via PDF download on our website at boldip.com. So it's been great talking with you here today. I'm your host, JD Houvener, USPTO patent attorney and managing partner here at Bold Patents. From all of us at Bold, go big, go bold.
Go big, go bold.